Listen carefully. You are 78 years old. It is a Tuesday morning. You're standing in the kitchen you have stood in for the last 40 years. Same cabinets, same old coffee maker, same family photos on the refrigerator. The birthday card from your granddaughter is still sitting near the phone. The house is quiet. Your spouse is upstairs. And for one normal second, nothing feels dangerous. Then your left arm goes numb. The coffee mug slips out of your hand. You hit the floor before your brain even understands what is happening. By lunchtime, you are in a hospital bed. By Thursday, a doctor is using words your family was not ready to hear. Long-term care. 24-hour supervision. Nursing facility. And then somebody in your family sees the number. $12,000 a month. Not a year. A month. Your daughter does the math in the parking lot. $12,000 times 12 months. That is $144,000 a year. Your Social Security check will not cover it. Your pension will not cover it. Your savings will not last. And the house you spent your entire adult life paying for, is suddenly not just a home anymore. It is an asset, a line on a Medicaid application, a number the state may look at later. And this is where the trap begins. Because most families believe Medicare will step in. They think, I paid into Medicare my whole life. Surely Medicare helps with a nursing home. But that is the part most people learn too late. Medicare generally does not pay for long-term custodial care, the kind of care where someone needs help bathing, dressing, eating, moving around, or being supervised every day. Medicare itself says most long-term care is not covered, and you generally pay 100% for non-covered long-term care services. So the family turns to Medicaid. And Medicaid may pay for nursing home care, but Medicaid is not just a health card. It is a financial microscope. It can look at assets, it can look at transfers, it can look back at what your family did before the crisis, and after a Medicaid recipient dies, states are generally required to seek recovery for certain long-term care costs from the estate of people who received those benefits at age 55 or older. That is why this video matters. Because the real question is not, will I ever need a nursing home? The real question is, if I do, what happens to the house? And if you own a home, have savings, or keep money in a brokerage account, there are 3 assets your family needs to understand before the crisis arrives. Not after the hospital room. Not after the social worker hands you the folder. Not after the Medicaid application starts. Before. Because once the clock starts, some doors may already be closing. Here's where the family makes the call nobody wanted to make. The nursing home bill is already running. The hospital wants a placement decision. The savings account is not enough, and Medicare is not the long-term answer. So the daughter opens her phone and searches how to get Medicaid to pay for nursing home care. That is when one letter changes the whole world. Medicare, Medicaid, 1 letter difference, 2 completely different systems. Medicare is the card most older Americans know. Medicaid is the program that may pay for long-term nursing home care, but only if you qualify under the rules. And those rules do not just ask, are you sick? They ask, what do you own? What did you transfer? Who did you give money to? When did you sign that deed? And most importantly, was it inside the last 5 years? That is the sentence that changes the room, because in many states, when you apply for long-term care Medicaid, the state can review years of financial records before the application. Not just yesterday. Not just last month. Years. Most families call it the 5-year lookback. And the lookback does not only search for fraud, it searches for transfers. Every gift, every check, every deed, every account that changed names, every we were just helping family moment. That birthday check to a grandchild. That money you gave your son after his divorce. That house deed you signed because someone said, just put it in your daughter's name. In your family, those were loving decisions. On a Medicaid application, they may look like transfers for less than fair market value. And if the transfer happened inside the look-back window, the question becomes painfully simple. How long will Medicaid refuse to pay? That is what most people do not understand. The state may not care that the money was for a wedding. It may not care that the deed was meant to make things easier. It may not care that nobody was trying to cheat the system. The paperwork sees a date. The paperwork sees a value. The paperwork sees a transfer. And once that transfer is flagged, the nursing home bill does not pause while your family explains the story. The monthly cost keeps running. The facility still expects payment. The family still has to find money. And the person who needed care still needs care. This is why the look-back rule is so dangerous. The mistake does not look like a mistake when you make it. It looks like helping your family. It looks like being generous. It looks like planning ahead until the Medicaid application turns that decision into a penalty. So, before we talk about the 3 assets families must understand, you need to see the math. Because the math is where the trap stops being theory and becomes a bill. Now, let me show you why this gets so dangerous. Most families think the Medicaid lookback is only looking for fraud. It is not. It is looking for transfers. And a transfer does not have to look suspicious when you make it. It can look like love. It can look like helping your grandson with a wedding. It can look like giving your daughter money after a divorce. It can look like putting your child's name on the house because someone told you this will make things easier later. But if that transfer happened inside the look-back period, Medicaid may treat it as a transfer for less than fair market value. And that can create a penalty period. A penalty period does not mean you go to jail. It means Medicaid may refuse to pay for nursing home care for a period of time, even if you otherwise need care. And here is how the math can work. The state looks at the value of the transfer. Then it divides that amount by the average monthly cost of nursing home care in your state. That gives the number of months Medicaid may delay payment. So imagine this. A father gives his granddaughter $30,000 for a wedding. No bad intent, no trick. Just a grandfather helping family. Then, 3 years later, he needs nursing home care and applies for Medicaid. If the state uses a nursing home cost figure of around $10,000 a month, that $30,000 transfer could create roughly a 3-month penalty period. 3 months where the nursing home bill still exists. 3 months where the family still has to find the money. 3 months where everyone is asking, who's going to pay this? Now make the mistake bigger. The family transferred the house to an adult child 2 years before the nursing home crisis. The house is worth $400,000. They thought they were protecting it. They thought they were avoiding probate. They thought they were keeping things simple. But if that transfer is inside the look-back window and does not fit an exception, Medicaid may count it as a disqualifying transfer. Using that same rough $10,000 monthly care figure, a $400,000 transfer could create a penalty period of around 40 months. 40 months. That is not a paperwork problem. That is a financial emergency. Because the care bill does not stop just because Medicaid says no. The facility still wants payment. The family still needs a plan. And the house you thought you protected may now be the reason Medicaid will not pay. This is why just put the house in your child's name. That can be one of the most dangerous pieces of casual advice older Americans hear. It sounds simple. It sounds loving. It sounds like family planning. But if it is done at the wrong time and the wrong way, without an elder law attorney, it may create the exact problem you were trying to avoid. And this is only the first blade. Because even if you survive the look back, even if Medicaid eventually pays, the state may still keep the receipt after death. That is called estate recovery. Medicaid paid the bill. The family breathed. And the state quietly started keeping the receipt. That is the part most families never hear clearly. Because Medicaid paying for nursing home care does not always mean the bill disappears forever. Sometimes it means the bill moves from the nursing home to the state ledger to the estate after death. This is called Medicaid Estate Recovery. In plain English, it means the state may try to get paid back from a person's estate after that person dies. And this is not a rumor. Medicaid.gov explains that for people age 55 or older, states are required to seek recovery from the person's estate for nursing facility services, home and community-based services, and related hospital and prescription drug services. So yes, Medicaid may help during life, but after death, the state may look back and say, we paid, now what is left in the estate? And that is where the house comes back into the conversation. Not because the state shows up with a moving truck, not because someone changes the locks overnight. The process is quieter than that. Paperwork, probate, a claim, a letter your children were not expecting. And for many families, the largest thing left in the estate is the home. This is where one sentence causes enormous confusion. The home is exempt. Families hear that and relax, but here is the part they miss. Exempt while alive does not always mean protected forever. Those are not the same sentence. The home may not block Medicaid eligibility today, but depending on your state, your family situation, and how the house is titled, it may still be exposed later through estate recovery. This is why incomplete advice is dangerous. And someone says, don't worry, Medicaid won't count the house. But they do not say, what happens after death? They do not say, does your state recover only from probate assets, or can it reach more? They do not say, is there a surviving spouse, minor child, disabled child, or hardship exception? They do not say, is the deed titled in a way that creates protection or creates a new problem? They do not say, did you start planning early enough for the look-back clock to clear? And that missing second half can cost a family the property they thought was safe. This is why the nursing home trap has 2 stages. Stage 1 is qualification. Can Medicaid pay now? Stage 2 is recovery. Can the state claim something later? Most families only ask the first question. How do we qualify? But the better question is, if Medicaid pays, what can the state recover after death? That is the question to ask before the hospital room, before the nursing home folder, before the 5-year look back becomes your problem. Because the state may not move fast. It may not argue. It may not explain. It may simply wait. And after death, it may use paperwork, probate, and estate recovery to claim what your family thought was already protected. Now we get to the part families wish they had heard 5 years earlier. Because once you understand the Medicaid trap, the next question is simple. What should we have looked at before the crisis? Not after the stroke, not after the fall, not after the hospital discharge planner says, we need placement, before. There are 3 assets that create the biggest problems for many middle-class families: the house, cash savings, and the taxable brokerage account. Why these 3? Because they are usually the most dangerous combination. Visible, valuable, reachable. Visible means the paperwork can find them. Valuable means they are large enough to matter. Reachable means if they are still owned or titled the wrong way, they may become part of the Medicaid conversation. And I want to be very careful here. I'm not telling you to transfer anything today. I'm not telling you to sign a deed. I'm not telling you to move money because a YouTube video scared you. This is general education. The point is to know which assets require a serious conversation with a licensed elder law attorney before your family is forced to make decisions under pressure. Asset number 1 is the home. For many seniors, the home is the biggest asset they own. It may also be the most emotional. And that is why families make rushed decisions around it. They add a child to the deed. They sign a quitclaim deed. They create a basic revocable trust and assume the house is protected. But a revocable trust is not the same thing as Medicaid asset protection. A revocable trust usually means you still control the asset. And if you still control it, Medicaid may still treat it as available, depending on the rules. A Medicaid asset protection trust, often called a MAPT, is different. It is generally designed as an irrevocable trust, which means assets placed in it may no longer be considered owned by the Medicaid applicant if properly structured and if the look-back period has passed. Asset number 2 is cash savings. This is the emergency account, the CDs, the money market fund, the account people keep because they say, I just want to feel safe. But if that money is still in your name when long-term care Medicaid is needed, it may have to be spent down before eligibility. In many states, a single nursing home Medicaid applicant may generally be limited to around $2,000 in countable assets, though exact limits vary by state and program. So a $100,000 savings account may not be safe money anymore. It may become the first account the nursing home bill consumes. But if you try to give it away too late, the look-back rules may create a penalty. That is why cash is not simple. Cash has a name on the account, a date on every transfer, a trail on every statement. Asset number 3 is the taxable brokerage account, your Vanguard, your Schwab, your Fidelity. The account full of mutual funds, ETFs, stocks, or bonds. Families often forget this account because it does not feel like cash. But Medicaid may still see value, and if it is moved carelessly, the family may create a second problem. Imagine a parent transfers a brokerage account directly to an adult child. Inside that account are investments that have grown for 20 years. Now the family may have a Medicaid transfer issue, a tax basis issue, and a family control issue all at the same time. The account was supposed to protect the family. Handled wrong, it becomes paperwork nobody understands during a crisis. So here is the rule for this module. Do not panic transfer assets, but do not ignore them either. The house, the savings, the brokerage account, those are the 3 folders that should be on the kitchen table before the nursing home folder ever arrives. Let's start with the house, because for most families, this is the asset that hurts the most. This is where your kids grew up. This is where your spouse planted the tree in the front yard. But Medicaid does not look at the house the way your family looks at the house. Your family sees memory. The paperwork sees an asset. That is the collision. And this is where people make the dangerous mistake. They wait until the crisis, then they panic, then someone says, just put the house in your child's name. That sounds simple. It sounds cheap. It sounds like a shortcut. But as we saw with the penalty math, a house transfer inside the Medicaid lookback window may create a penalty instead of protection. A deed is not just a piece of paper. A deed is a transfer. And if Medicaid sees that you transferred the house for less than fair market value during the look-back period, the state may treat it as a disqualifying transfer. That means the house move you thought protected your family may be the move that delays Medicaid payment when care is needed. But the Medicaid penalty is not the only risk. When you put a child directly on the deed, you may also expose the house to that child's problems. Their divorce, their lawsuit, their creditors, their bankruptcy, their bad marriage, their financial mistakes. You may think you are giving your family security, but without proper planning, you may be tying your home to someone else's legal life. So the question becomes, if signing the house directly over to a child can create new risks, what does more careful planning look like? This is where elder law attorneys often discuss tools like a Medicaid Asset Protection Trust. A properly drafted Medicaid Asset Protection Trust is usually irrevocable. That word scares people. Irrevocable means you do not control it the same way you control a normal revocable trust. But that loss of control is not a mistake. It is the point. If you still fully control the asset, Medicaid may argue it is still yours. If the trust is properly created, properly funded, and enough time has passed, the house may be treated differently under Medicaid rules. Those three conditions matter. Properly created means the trust language has to match your state's rules and your family situation. Properly funded means the house actually has to be transferred into the trust. A trust document sitting in a drawer does not protect a house that was never moved into it. Enough time passed means the look-back clock has to clear. In many states, that means 5 years. Do not miss that. A house transferred yesterday may be a problem. A house planned for years ago may be a different conversation. That is why the question is not, should I put my child on the deed? The better question is, what is the safest way to protect the home under my state's Medicaid rules, tax rules, and family situation? That question belongs with a licensed elder law attorney, not a neighbor, not a bank teller, not a random person at church, and not a YouTube comment. Because one wrong deed can create 5 years of consequences. Now let's talk about the asset most families think is safest. Cash. The savings account, the CDs, the money market fund, the emergency account, the money your parents kept because they were careful, because they did not trust the stock market, because they lived through layoffs, inflation, medical bills, and years when every dollar had to be watched. This is not just money. This is a personality. This is a generation. This is 40 years of saying, don't spend it. We might need it one day. And emotionally, that makes sense. Cash feels safe. Cash feels simple. Cash feels responsible. But during a long-term care Medicaid crisis, cash may be one of the first assets exposed. Because cash is easy to see, easy to count, easy to trace. And if it is still in the applicant's name, Medicaid may treat it as an available resource. This is where families get shocked. They say, but that money is for emergencies. And the system says, this is the emergency. They say, that account is for the kids. And the paperwork asks, whose name is on the account? They say, my mother saved that money for 30 years. And the rules ask, is it still hers? That is the collision. Emotional ownership versus legal ownership. And Medicaid deals in legal ownership. Now picture this. Your father has $100,000 in savings. Not rich, not reckless, just careful. Then the nursing home says $12,000 a month. That $100,000 looked like security on Monday. By Tuesday, it looks like 8 months of care. And if Medicaid eligibility requires the applicant to spend down countable assets before benefits begin, that account may disappear much faster than the family ever imagined. This is why cash planning has to happen early. Because giving it away too late can be just as dangerous as doing nothing. A daughter says, Mom, just move the savings into my account. A son says, Dad, write me a check and I'll hold it for you. A parent says, we'll deal with this when the time comes. But if that transfer happens inside the look-back window, Medicaid may ask, when did the money move? How much moved? What did the applicant receive in return? And if the answer is nothing, the transfer may create a penalty. So cash creates a brutal choice when families wait too long. Keep it in the parent's name and it may be spent down. Move it too late and it may be penalized. Move it casually and it may create family conflict. That is why the savings account deserves its own plan. Not panic, not a secret transfer, not a last-minute check. A real conversation. If a family is considering a Medicaid asset protection trust, cash may be part of that discussion, but only if the attorney says it fits the state rules, family needs, tax picture, and timing. Some cash may need to stay available, some may be planned differently. Some may be needed for comfort, home repairs, transportation, or a spouse still living at home. This is not about emptying every account, it is about knowing what each account is exposed to. So when you review cash savings, ask these questions. Whose name is on the account? Is it countable for Medicaid? How much must stay available for living needs? What happens if care is needed inside 5 years? Would transferring it create a penalty? And who has legal authority to manage it if the parent cannot? Because cash may feel like the safest asset in the family. But when long-term care starts billing by the month, cash can become the first thing the crisis consumes. Now let's talk about the third asset, the taxable brokerage account, your Vanguard, your Schwab, your Fidelity, the account your family built slowly, not overnight, not with lottery money, but with leftover paychecks, reinvested dividends, old stock positions, index funds, and the hope that one day it would help your spouse, your children, or your grandchildren. And that is why families miss the danger, because the brokerage account does not feel like cash. It feels like planning. It feels like responsibility. It feels like something separate from the nursing home conversation. But Medicaid may still see value, and if that account is in the applicant's name, it may become part of the eligibility review. That creates two common mistakes. Mistake one, The family leaves the brokerage account untouched and assumes it will pass smoothly to the children later. But if long-term care Medicaid is needed first, that account may be treated as an available resource, depending on the state and the situation. Mistake 2, the family panics and follows dangerous casual advice. Just get it out of your name. That sentence can create a mess, because a brokerage account is not just a pile of dollars. It may contain investments that have grown for 10, 20, or 30 years, and those investments may carry unrealized gains. In plain English, that means the account may be worth much more today than what you originally paid for it. That matters because inherited assets may receive a step-up in basis after death. The IRS explains that basis for inherited property may be determined using the appraised value at the date of death in certain circumstances. That can reduce capital gains when the inherited asset is later sold. But a lifetime transfer can be different. If a parent transfers appreciated investments directly to an adult child during life, the child may receive the parent's old cost basis instead of a fresh basis at death. So the family may avoid one problem and create another. A Medicaid transfer issue, a tax issue, and a family control issue. All from one sentence. Just get it out of your name. This is why brokerage planning has to be handled carefully. For some families, an elder law attorney may discuss whether a properly drafted Medicaid Asset Protection Trust can hold investment assets. But even then, the tax structure matters. Some Medicaid Asset Protection Trusts are designed as grantor trusts for income tax purposes. That sounds technical, so here is the plain English version. The trust may own the assets for Medicaid planning purposes, but for income tax purposes, the income may still be reported by the person who created the trust. That can matter because it may preserve certain tax treatment and avoid creating a separate trust tax problem. But this is not automatic. It depends on the trust language, it depends on the assets, it depends on state law, and it depends on tax advice. That is why Medicaid planning is not only Medicaid planning, it is tax planning, it is estate planning, it is family control planning, and it is timing. So before anyone transfers a brokerage account, ask these questions. Who owns the account? What gains are inside it? Would a transfer trigger Medicaid lookback issues? Would direct gifting damage tax treatment? Should this be reviewed by both an elder law attorney and a tax professional? Because the brokerage account is not just a portfolio. It is paperwork. It is tax history. It is Medicaid exposure. And if your family ignores it until the nursing home application arrives, it may be too late to fix it cleanly. Now pause the story for a second. Go back before the stroke, before the nursing home folder, before the daughter was doing math in a hospital parking lot. Imagine the same family 5 years earlier, sitting at the kitchen table with the deed, the savings statement, and the brokerage account in front of them. That is where this conversation should happen. Not in panic, not under a deadline, not while the bill is already running. This is where families usually hear about a tool called a Medicaid Asset Protection Trust. You may hear people call it a MAPT. And before we go any further, understand this clearly. This is not a magic trick. This is not something you download from the internet. This is not a form you print at home and sign next to the coffee maker. A Medicaid Asset Protection Trust is a serious legal planning tool. If it is drafted wrong, funded wrong, timed wrong, or used in the wrong state, it can create more problems than it solves. But when families talk to an elder law attorney early enough, this is often one of the tools that comes up. Here is the basic idea. If an asset is still legally yours, Medicaid may be able to treat it as yours. But if an asset was transferred into a properly drafted irrevocable trust, and enough time has passed under the look-back rules, that asset may be treated differently. The key word is irrevocable. A revocable trust is something you can usually change, control, cancel, or take assets back from. That can help with probate planning, but it usually does not create the same Medicaid protection people assume. A Medicaid Asset Protection Trust is different because you generally give up direct control over the principal. That is the hard part. Most people want protection without giving up control, but the system does not usually work that way. If you can take the asset back whenever you want, Medicaid may ask a very simple question. Then, is it really gone? That is why these trusts are often designed with someone else serving as trustee, often a trusted adult child or another responsible person. But that choice matters. A bad trustee can damage the whole plan. If the trustee mismanages money, refuses to cooperate, gets pressured by siblings, or treats trust assets like family spending money, the legal document does not feel very protective anymore. And timing matters just as much. If you need care in 2 years, but the look-back period is 5 years, the trust may not have cleared the clock yet. That is the part families misunderstand. Creating the trust is not the finish line. Funding the trust starts the clock. The house has to be moved into it. The cash has to be moved correctly. The brokerage account has to be retitled carefully. And then the family has to wait long enough for the transfer period to clear under state rules. Other risks still matter too. What if the child trustee gets divorced? What if the trust language does not match your state's Medicaid rules? What if the brokerage account creates tax problems? What if one spouse needs care and the other still needs money to live safely at home? This is why a MAPT is not a product. It is a plan. And the plan has to fit the state, the family, the health situation, the tax picture, and the timeline. So the question is not, can a trust protect everything? The real question is, what would our family look like if we'd started the clock 5 years earlier? Because in the next example, two families will face the same nursing home crisis. Same house, same savings, same care bill, but one family planned early, and the other waited until the folder was already on the table. Now let me show you why timing matters. Because two families can have the same house, the same savings, the same nursing home crisis, the same state, the same monthly care bill, and still end up with completely different outcomes. Let's call the first man Arthur. Arthur is 78. He owns a home worth $400,000. He has $150,000 in savings. He has a small taxable brokerage account worth $100,000. Total family assets outside normal income, about $650,000. Arthur never thought of himself as rich. He was careful. He worked. He saved. He paid off the house. He wanted to leave something behind. But Arthur did no Medicaid planning, no elder law meeting, no trust conversation, no review of the deed, no review of the accounts. Then Arthur has a stroke. He enters a nursing home. The bill is $12,000 a month. At first, the family uses savings. Month after month, the account drops. The money that took decades to build starts disappearing in less than a year. By the time Arthur may qualify for Medicaid, much of what he saved is already gone. And now the family is dealing with the second blow, estate recovery. Maybe Medicaid starts paying, but every dollar Medicaid pays for long-term care may become part of a later recovery claim, depending on the state and the estate. Arthur dies. The family opens probate. The house is still in Arthur's estate. The state files a Medicaid Estate Recovery claim. The children thought they were inheriting the family home. Instead, they are dealing with paperwork, claims, deadlines, and a house that may have to be sold. Now compare that with Arthur B. Same age, same house, same savings, same brokerage account, same medical crisis. But 5 years before the stroke, Arthur B. sat down with a licensed elder law attorney. Not after the diagnosis, before. He reviewed the house, he reviewed the savings, he reviewed the brokerage account. His attorney explained the state rules, the look-back period, tax issues, family control issues, and what could happen if nursing home care was needed later. Maybe that plan included a Medicaid Asset Protection Trust. Maybe it included different tools. The point is not that every person needs the exact same document. The point is that Arthur B. started early. So when the crisis came, his family was still scared. They were still tired. They were still sitting in hospital chairs, answering phone calls and trying to make decisions nobody wants to make. But they were not learning the rules from scratch. They knew where the paperwork was. They knew who had authority. They knew what had been transferred. They knew when the clock started. They knew which assets were inside the plan and which assets were not. That does not mean everything becomes easy. Nursing home crises are never easy. But there is a difference between handling a crisis with a plan and discovering the rules while the bill is already running. That is the central lesson. The legal tool matters, the asset matters, the state matters, but the clock may matter most. Because Medicaid planning is not something you do when the nursing home application is already on the table. By then, the system may already be asking questions about the last 5 years. And your family may be trying to solve a problem that started long before anyone knew there was a problem. This is where families make the most expensive mistake. They think planning starts when the crisis starts. It does not. By the time the nursing home application is on the table, the look-back clock may already be working against you. And in many states, that clock reaches back 5 years. That part you already understand. But there is another clock families miss. Not the Medicaid clock, the capacity clock. Because planning requires someone to be legally able to sign a trust, a deed, a power of attorney, a beneficiary change, a financial authorization. All of it depends on capacity. And capacity is not something families get to assume forever. A person can be physically alive, they can be sitting in the room, they can still recognize family, and still may not have the legal capacity needed to understand and sign certain documents. The Alzheimer's Association notes that as long as a person has legal capacity, they should take part in legal planning, and that a lawyer can help determine what level of capacity is required for a particular document. That is why waiting is so dangerous. Families think, we'll handle it when mom gets worse. But when mom gets worse, the easiest planning options may already be gone. Now the family may need court involvement, guardianship, conservatorship, extra legal fees, more delay, more stress, more strangers involved in private family decisions. That is panic planning. Panic planning is standing in a hospital hallway, searching the internet, calling attorneys, trying to understand Medicaid, while the bill is already running and the person who needs care may no longer be able to sign. That is the worst time to learn the rules. The better time is before. Before the fall, before the stroke, before the dementia diagnosis becomes a legal barrier, before the discharge planner says, we need a long-term care placement. So if you are watching this while there is still time, do not make your first move a transfer. Make your first move a conversation. And bring these 4 questions to a licensed elder law attorney in your state. Question 1, if I need long-term care, what happens to my home under this state's Medicaid rules? Question 2, what assets are countable and what assets should stay available for my own care and comfort? Question 3, if I create a trust or transfer assets, what happens if I need care before the 5-year clock clears? Question 4, do I still have the legal documents and capacity needed to act before a crisis? Those 4 questions are better than panic, better than guessing, better than copying someone else's plan, because Medicaid is state administered. Details matter. Florida is not Ohio. Ohio is not California. California is not Texas. A strategy that works in one state may fail in another. So the first move is not signing a deed. The first move is not moving money. The first move is asking the right questions while the person who owns the assets can still legally answer. So here's the whole point. The danger is not that families are careless. Most families are not careless. They love their parents. They want to protect the house. They want to do the right thing. The danger is that the rules usually appear after the crisis has already started. The hospital room comes first, then the nursing home folder, then the monthly bill, then the Medicaid application, then the request for 5 years of financial records. Then the family finally realizes, we should have asked these questions years ago. That is the trap. Not because every family loses the house, not because Medicaid always takes everything, not because one rule works the same in every state, but because timing matters more than most people are ever told. If you own a home, keep cash savings, or have a taxable brokerage account, those 3 assets deserve a serious review before anyone needs long-term care. Not panic, review, not fear, preparation. This is not about hiding money. This is not about tricking Medicaid. This is about understanding the rules before the rules are being applied in the middle of your family's worst week. So tonight, do something simple. Take out a notebook. Write down 3 headings: home, cash savings, brokerage account. Under each one, write what you own, whose name it is in, and whether your family knows where the paperwork is. Then write one question at the top of the page. What happens to this if I need nursing home care? That one question can change the entire conversation. Bring that page to a licensed elder law attorney in your state. Ask about the Medicaid Lookback period. Ask about estate recovery. Ask about whether your home is exposed. Ask about whether a Medicaid asset protection trust makes sense. Ask what happens if care is needed before the 5-year clock clears. Ask what should remain available for your own comfort, safety, and dignity. Because a good plan does not just protect assets. It protects choices. It protects dignity. It protects the surviving spouse. It protects adult children from making rushed decisions in a hospital hallway. And sometimes, it protects the family home from becoming just another number on a form. That is why this matters before the crisis. Because after the crisis, the family may still have options, but they may have fewer options, worse options, and less time to understand them. If this video made the nursing home trap clearer, like the video so YouTube can show it to another family before they face the same decision, subscribe to Rights Brief USA for plain English legal education about the rules families usually learn too late. And comment. Look back. Below, if nobody ever explained the 5-year Medicaid rule to you clearly, do not wait for the fall, do not wait for the stroke, do not wait for the folder.